Hi, good afternoon, everyone. This is Rajiv S. Khanna for Immigration.com, the law offices of Rajiv S. Khanna PC. Today is February 6th, 2014. This is a community conference call. Just going to dive right into the questions that have been posted. Then we will deal with any follow-up questions on that which has been posted. And at the end of our conversation, we will then take on all new questions. I think we'll have enough time to take on plenty of new questions if there are any. Going back to the first question. So here the situation is Kepson left the United States while they were on withholding of removal status, and they want to come back after 5 years and they're a naturalized French citizen. They want to come back to the United States for a visa for some kind of an expo. The question is, can I get a B1, B2 or no? And the fact that they had applied for political asylum and they've gone back to the country from which they had applied for political asylum, is that going to be a problem? I am by no means an expert in deportation asylum issues. Our practice is we're very heavily focused on business and employment-based immigration. We do very little in deportation, etc. But my guess is you have no choice but to try. As long as you do not tell anything which is other than the strict truth during the application for your visa, I don't see how things can get any worse. Okay. My feeling is, again, I'm not aware of all the ramifications of your situation. If you want to do a consultation, you should with a lawyer who does deportation and political asylum cases. But going by what I do know, I don't think there is much you're going to be able to do except try. And I personally think you'll get your tourist visa if the consulate is so inclined. Okay. Next question is REIS, immigration proceedings terminated without prejudice. Now here the situation is a little bit different. They had on a religious visa worked without authorization, and an earlier 485 was denied because of that. Then they were put in deportation, but the judge decided to terminate the deportation without prejudice. Now they are married to a U.S. citizen, and do I think they're going to be able to get their change of status, adjustment of status? And I think, again, this is another one of those situations where you don't have a choice. Okay, you're going to have to try. Now, adjustment of status is a discretionary remedy. It can be denied for any number of reasons, including improper conduct. However, this was a long time ago. Proceedings were terminated. I think you should be okay. But please be careful before you travel. Of course, you need an advance parole before you travel. But make sure you have no unlawful presence issues, because if you travel while the green card is pending, you could end up being barred from entering the United States for 3 or 10 years. So don't travel without consulting a lawyer in detail, okay? Janisha wants to know, will conviction affect my citizenship? So we've got a shoplifting conviction. Oh, it's not actually a conviction, it's still pending. So permanent resident since 2005. And they also were not sure if they were posting this in the correct thread. No, this is fine. This is the right thread. If you want me to answer this question, definitely this is the right thread. And well, first of all, in order for your citizenship application to be affected, there must be a conviction. The many state courts will allow you to walk away from a situation like this with some kind of a community service without there being actually a conviction entered on the record. When you have criminal convictions, not only do we worry about naturalization, we worry about your green card being taken away. It looks to me that it's at worst, it is a misdemeanor, but I'm not sure, where the punishment, maximum possible punishment is less than a year, or is it a year or less, one of the two. If it is indeed one misdemeanor in all your life, your green card will be protected by something called petty, P as in Peter, E as in elephant, T as in Tom, T as in Tom, Y, petty offense exception, which allows you to be convicted of one misdemeanor through your life in the United States and not have a problem. Okay. Would that be a problem for your naturalization? It can be. The government technically only goes back 5 years to look into convictions, but there's nothing stopping them from going further back. If it were a felony, you would have a different kind of problem. But this is a misdemeanor, and I think you should talk with your criminal defense counsel. Your court date is next month. Talk with your criminal defense counsel. Make sure they consult an immigration lawyer also, because sometimes criminal defense counsel thinks, oh, this is not a conviction. Next thing is, under immigration law, it really is a conviction, even though you don't, under criminal law, it's not a conviction. So it's a little tricky issue. It'll be great if you can walk away from this without a conviction. And if you do, I think you should be okay with your naturalization application. Amending to littering, well, if you can amend to anything which is not a crime, or you can amend, or you can do some kind of a state procedure where it's not a conviction, you should be okay. IVT 643, H4 to H1 to H4 to H1. So they want to go from H4 to H1, then back again to H1. Came to US on H4, got approved under H1, did not work because of personal reasons, changed back to H4. Since I'm on H4, I want to start work. What are my options? Well, you're not subject to the quota because, let's see, in April 2007, so within the last 6 years, you had an H1. So you should be able to convert to an H1 without having to wait for the quota. Okay. If somebody has had an H1 approval within the last 6 years, even though you never worked, you still should be exempt from the quota. Next question is similar, H4 to H1B and H1B to H4. I am on H4 right now. I'm looking for an employer who can file H1B so I can work. Suppose employer A files H1B in April. It gets approved. What would be my status after H1B approval? By the way, there are two questions here today that I think I should deal with separately. We should have a full video on that because they deal with some important issues about H1B conversions, etc. So if you are on the phone right now, I would do this question right now, otherwise I'll do a separate video for it. If you who has posted this question in M38, question number 7, or is it 6? 6, about H4 to H1B and H1B to H4 conversion, press *5 on your phone. I want to see if you are here. Press *5 if you are here. Okay. So what I'll do is I'll actually do a separate recording for this between today and tomorrow, and I'll post it on my blogs. Just watch my blogs. I'll have a separate recording for this question. It's important enough for us to have a separate topic on this. Okay. Then again, in M38, that's a continuation of the same set of questions. I'll take care of all of this between today and tomorrow. I'll do a separate video for you. Next question is Pavinder, who wants to know about filing form N470. He's going to take a job in India for an American company, the subsidiary of an American company. He's been working for the same company in the United States. Had a green card since 2009, but was in India from 2010 to 2012 and have been physically present in the US for more than a year now. What are the requirements of filing N470? Well, there's a bunch of them, but the most important for you right now would be that you have been in the United States for at least one year period during which you did not leave the US even for one day. So since getting the green card, there must be at least a 1 year period during which you did not step outside the US even for one day. What all would I need from my employer to file Form N470? Basically, the employer provides a letter showing that the company in, are you from India? Yes. Company in India is a subsidiary of the American company, and or that the US company actually, and the US company is engaged in um, advancing the trade and commerce of the United States, and that you are going to be working outside towards the same company and cause. Um, Basically, that's the kind of letter you get, and based upon that, you apply for N470. Odin 2357, citizenship application process. My green card was started in 2002 by employer A. 485 was done in 2004, and he was working in an IT related role. Got into MBA in 2004, also continued working. 2007 switched to employer B for a non-IT role. Feb 2008 switched to C, again in an IT related role, very similar to the green card application. Green card was approved in 2009. No AC-21 was ever filed. See, the job through which you got your green card and the job that you were doing at the time of the green card approval are substantially same or similar. So you should be able to get the benefit of the AC-21. AC-21 filing is not required. Okay, I wouldn't be concerned about this situation as long as the job with employer A, and for which they filed the green card, and the job with employer C, the 2009 job, are substantially same or similar. You should be okay. Next question is from May Prayers, who wants to know if they can withdraw an affidavit of support. You cannot. You cannot. Okay, once it's been filed, case has been approved, you cannot withdraw your affidavit of support. Next question is Nian TKS, question number 12. US citizen got married to a girl from India. So she had a tourist visa stamped before she got married. The question is, we've got our K1, K3, etc. going, K3 going. Can she enter the US on a tourist visa? I would not advise it. I would not advise it. Because if she lands at the airport and they ask her, why are you coming in, she has to tell the truth, that her husband is in the United States. If she does not tell the truth, they can consider that to be fraud, and that would be a problem for her green card. If she does tell the truth, it's highly likely that they will turn her back at the airport. Not 100%, but it's highly likely. If you want to do this right, have her go back and apply for a tourist visa again. Explain to the consulate that she's now married to a US citizen and she wants to go in. If she comes in using that visa and reveals all the facts to the CBP at the airport, they still let her in, there is no problem. Okay? If you want to do it this way. OGL 2014 says changing employers 3 months after getting employment-based green card. So they've been working for a university for the last 9 months. 2 months ago, they got their green card through EB1. So they want to go from academia to the commercial world relating to their own field of expertise. Is this committing fraud? So 3 months after I get my green card, I want to change my jobs. I don't see any problem with it. If at the time your green card was approved, you had the intention of staying with this employer and later on you change your mind and leave, that's perfectly okay. My present employer is not happy with my decision. Can they inform USCIS and request for revoking my green card? They can do what they want. I don't think USCIS will revoke your green card. I don't see any grounds for it. Are there any cases in which the green card was revoked in this type of situation in the past? I am not aware of any such case. And I do keep track of all the latest developments in the law. So I don't think it's going to be a problem. USCIS is always unpredictable. You never know what they are going to do. But I personally don't think this is a problem. Optimist wants to know, she's got a bunch of different name presentations. In the passport, her last name is blank. In the US visa, her first name is shown as first name unknown and last name is shown as her full name. Social security number is slightly different. Driver's license is again first name unknown. EAD card, first name unknown. I-94, first name unknown. So it looks like the USCIS records all show you as first name unknown. Even the consular records show you as first name unknown. Okay. So what you want to do is get your H1 as cleanly as possible. I guess you could continue using your first name unknown status. And somewhere along the line, I think you should go ahead and correct your passport. Go ahead and correct your social security number. Actually, that one is already correct. Correct your passport, and then in the next filing with the USCIS, correct your name with them as well. Okay. So for now, I guess there can be consistency and you can use the same thing. Although this is a little tricky because your social security number, let me think about this. Your social security number contains your real name. Why don't you use your real name with the USCIS now? I think that's what I want to do. So use your name, Pooja Jindal, no first name unknown, Pooja first name, Jindal last name. Use that in your H1 filing. That is in line with your social security number. At the same time, try to get your passport corrected with Pooja Jindal, first and last name. That will actually make everything okay. That's the way I would probably do it. Okay. Lolo 2014. Once again, I repeat, Pooja. File your H1 as Pooja, first name, Jindal, last name. That's the same as your social security number. At the same time, try to get the passport corrected. That should take care of everything. Lolo 2014 says, N400, I have been on green card since 6.5 years. 4 years worked with employer A. In 2006, left employer A, joined B for a temporary project. Employer A filed I-140. 2007, filed I-485, went back to employer A and got green card after 90 days. Then a few months later, 5 months later, got laid off. Since 2007 to now, they've been working with other employers on same capacity. Currently unemployed, filed for N400. Is there any issue because I joined employer B before green card, although temporarily? I don't see any issue. Do I need documents from sponsor? No, I don't think so. I have W-2s for all years and pay stubs. Green card was approved without interview. I think you're fine. I sent 3-year taxes with N400. I plan to take all paperwork. Sponsor is now out of business. I think you'll be fine, Lolo. I don't see any problem here. Okay. RAD 1980, this is a little bit complicated fact pattern. I'm not sure I understand it completely. Entered on L2 visa as dependent on spouse, got EAD, got a job, H1B with the new employer, got approved. After 1.5 years, found another employer who started the H1B transfer. And you joined that employer, the second employer, with the H1B transfer receipt. Started the project as contractor to client under my new employer. In the meantime, old employer revoked the previous H1B. Now this project has ended. So you've got a transfer pending, but the project has ended. Got it. New employer has processed payroll till last week, and they are going to revoke the H1 unless a project is found. Spouse has got a new job, he's got his H1B, and he switched to his new job. He's having an approved petition of H1B valid till 22nd September. So the questions are, if my current employer does not get a project for me and terminates me on in the third week of Feb, will I be considered out of status? Yes. Because the H1B transfer petition is still pending. Well, the thing is, because the project is gone, that pending petition may not be able to protect your status. Although it's not a simple situation, it's a fairly complex situation. But it appears to me, I would venture to argue that as soon as you don't have a project and you are out of work, that pending petition does not protect your status. You're not unlawfully present while that is pending, but you are not in status, in my opinion. Is it mandatory to have a pay slip till the date I file my I-539? Yes. Yes. You should be in status till the date you file your H4. I know H4 will take 3 to 4 months. I can't take a new job until the H4 is approved. The answer is, well, you can. You can take a new job, but the rule is, if there is a prior application pending, like H4, from which you derive your status, and time comes for them to approve the H1, if at the time your H4 is not already approved, they will make you go outside USA for visa stamping. So the worst case scenario is, if the H4 is not approved by the time they decide your H1, you just go outside USA and get a visa stamping. Of course, that has its own issues, but technically that's what you would do. My spouse is on H1B. Can I go to India alone and get my H4 visa stamp? Well, yeah, you can try. Sometimes they insist that we'll only give you an H4 if your spouse gets an H1 visa stamping. And they can get it from Canada or Mexico if that should come up. This way I don't need to wait for 3 to 4 months and I can come back and look for a job. Yeah, sure. As per CBP website, my current I-94 is 2nd November 2014 under L2. So does this mean I'm valid status till this date? No, you're not, because your husband is on H1B, not on L1. When will and what time I become out of status? You're already out of status, in my opinion. If you're not working and getting paid on an H1B, the fact there's a transfer pending does not keep you in status. Can a new employer transfer my pending H1B? And the answer is no. You'll have to go outside for a visa stamping. These are all interconnected. If you are deriving your status from the pending H1 or pending H4, they must already be approved for you to get a change of status or extension within the United States. Okay. I think going out for H4 visa may be the only real good option you might have. Next question, number 17, is about a DS-160 form. And they want to know, should I be disclosing the fact that I fell out of status during F1 and had reinstatement done? And the answer is, you should always err on the side of too much disclosure rather than too little. You should answer it yes. And that should not become a ground for denial of H1. Next question, they want to know if I have a sample birth certificate and affidavit. I don't have a sample birth certificate, but affidavits I'm sure we have. You can send me an email to help@immigration.com. I'll be happy to email you a format that we use. Ruhul 786. So mother applied under Uncle applied for mother under family 4 category. At that time, age was 16 years. Now I'm 28. Am I still eligible? Not unless the I-130 was pending for 8-9 years. The time for which the I-130 is pending gets subtracted from your age today. So if it's pending for 10 years and today you are 28, we subtract 10 years, the time during which your I-130 was pending, from your age today, and that is what your age is for green card purposes. Okay. Your uncle cannot apply for your I-130. They cannot. Okay. Next question. Rahul Mittal, number 20, H-1B renewal stamping. So here H-1B renewal was approved and it's not been withdrawn under Company A, which is his brother's company, in 2013. Company B filed for H-1B in September, still under process. Moved over to Company B. Company B terminated. I'm getting severance pay until Feb. I've rejoined Company A. You know, this is tricky. I'm not sure. If you had asked me a few years ago, I would have said this is okay. But since the government has started taking this position that Company A is duty bound to revoke your H1 when you leave, I'm not sure that Company A's H1 is still valid. And I don't think there is any good answer to this. You'll find a lot of people saying, yes, it is still valid, and a lot of people saying, no, it's not valid. I'm not sure I can give you a good answer. Can I draw salary starting January 16th? Please note that I'm getting severance pay until Feb 15th. Whenever you have two salaries coming on one H1, what we have to analyze is, are you actively working for both companies? Because the severance is for time already worked, or it is for things that have already happened. I don't think it's a problem getting two salaries under this situation. Should I explain the whole situation to counselor during interview? Sure, you can, and in my view, this is not illegal. Would it not raise red flag to consulate when they see my pay stub from both companies? And the answer is, well, what do you care? As long as it's legal, the flag can be red, blue, yellow, orange. We don't care. I think it's okay. AKS 341, question number 21. They've got an H1 beyond what they should have gotten. So instead of 13 months, which according to their calculations is what they should have gotten, they've got 3 years. Well, what happens is, if USCIS gives you more time than you have coming, what they say is, don't misuse it. If you misuse it, we, USCIS, reserve the right to deport you. Okay. They've never done that against anybody, because I'm not sure any court would look upon it kindly if USCIS is making a mistake. But I would advise you to have the calculation double checked with your lawyers, and if it is indeed only 13 months you are entitled to, behave as though you only have 13 months. Don't take advantage of the extra time. That would be my advice. Sandy wants to know N400 and stamp on passport. I'm a citizen of India, got my green card through employment. I've applied for my citizenship. I've lived in the US continuously, barring 3 weeks to India every year. I have some traffic violations, nothing major, from 8 years back. No serious tax complaints, crime-free, clean immigration record. Currently employed, rent a house. I'm going for my citizenship interview by the end of this month. Last month, I shipped my household goods by sea to India. I used transfer of residence with Indian customs. Now the question is, since that was not the truth, is this going to be a problem? And the answer is, I don't think so. First of all, it's not something that you've done in the United States. If you have done something with the Indian customs, I don't see how this is relevant for the American purposes. I don't think this can be a ground for denial. I don't think it should come up. I don't think it's a ground for denial of an N400. So the fact that you are renting by itself should not be an issue. Last question is from Flower Girl 123. Do substitute teachers qualify for H1B? And the answer is sure. As long as the job requires at least a bachelor's degree in education or equivalent, you do qualify for an H1B. Okay, let's do follow-up questions. Anyone who has a follow-up question on what I have discussed, no new questions please, press star 5. Star 5 on your phone. 2 questions. And once I'm finished with these, then we'll start with all the new questions. 3 questions. Okay. I'm going to unmute you in the order in which you logged into the conference. Okay. California. Go ahead, please, California.
Yes, I was wondering for my N400 application if there is any issue for the green card. And question number 10.
Question number 10. Give me 1 second. Let me get up there.
If I file the N400, does it put my GC at risk at all? Or?
Oh, no. See, because employer C and employer A's jobs were very similar, I don't think this is going to be an issue at all. Okay.
Okay.
I've had
Even
other.
though I was working
No, that's
employer B in a non-IT role? Or?
So what? You see,
An MBA also?
I think
no problem, MBA?
I don't see any problem with it. A government can come back and start questioning your intention, but the fact still remains. October 2009, when the green card was approved, you were working in your own field. Same or similar to the green card job. I think you're going to be just fine.
Yes.
Don't worry.
Okay.
You'll be okay. All right?
Thank you.
Good luck. Okay. We have 2 more questions only from follow-ups. Georgia, go ahead please, Georgia. Marietta, Georgia, area code 678. Go ahead. Okay.
Hello, sir. I have a question regarding the H4 and H1B. It's question number 6 and 8.
1 second, ma'am.
Could you please answer that?
Okay. I wanted to do a separate video for this. I can do it one of the 2 ways. I can either do it this afternoon and email you the responses, when I put it on my blog. Or if you are really in a hurry, I can do it right now and I can try to splice out this portion of our conversation. Let me do it right now. I can copy and take out this conversation and post it as a separate entry in the blog. So let's take your questions. Okay. Before I get to this, can I ask you to hold 1 minute and let me answer that one last call that somebody has, and then I'll answer your questions, then I'll take new questions, okay? Hold on. Campbell, California, go ahead, please.
Hi, Rajiv. This is question number 21, AKS 341.
Okay.
Regarding the extra time for which the H1 petition has been approved.
Sure, I remember.
And I went through the petition that the attorney for my new employer has filed. And I looked at the specific question where the petition asks for the last 6 years during which I have held H1B status. So essentially, it seems in the petition, the attorney did not provide my history before the last 6 years, and requested for 3 years of H1B. And probably that is why the USCIS approved the 3-year H1B instead of just 13 months.
Well, they should have also checked. Nevertheless, if this is an error, it should not be exploited. That's my opinion. Okay.
Okay.
You can
So-
just take the 13 months that you have and continue, and then make your plans accordingly.
So right now, my only plan is that my employer has agreed to file for a green card, so I should ask them to file for a green card immediately so that they file the form before 365 days before the end of my 6-year period, so that I will get some extension. Otherwise, after 13 months, I cannot continue that.
Definitely.
Okay.
All right.
All right. So do I need to request my attorney to file a case or something to correct the error that has already happened?
You should send an email to the lawyers and let them do what they think is appropriate. You are not the expert, they are. And H1 is not your case anyway, it's the employer's case. So send them an email, send your employers an email, let them decide what they want to do. As far as you are concerned, you only have 13 months of H1. Okay?
Okay.
Good luck to you.
All right.
You're welcome.
Thank you.
Bye-bye. Okay, folks, for the next about 8 or 10 minutes, I will be dealing with these questions that come up quite frequently. And I will extract this part of the conversation and put it in our blogs so people who are not attending the conference should at least know what these basic concepts in H1 quota are. Okay? Ma'am, are you here? Can you hear me? Ma'am?
Yes, sir.
Okay, yeah, speak up a little bit because your voice is not, just speak up, okay? I'm going to go to question number 6. So here it is. I am on H4 right now, and I'm looking for an employer who can file an H1B for me this year so I can work. Supposing an employer A files H1B in April, and the H1B gets approved. What would be my status after H1B approval? Will it be H4 or H1B? What is your guess? Ma'am, what is your guess?
I would be on H4 till October 1st.
Absolutely correct. Till October 1st, you will be on H4, and then on October 1st, you will, if you have received a change of status, be on H1B. Now remember, you can always file an H1B without a change of status. So you get the approval, but in order for you to then change status from H4 to H1B, you either have to apply for change of status again or go outside for visa stamping. That means in that case, on October 1st, you will still be on H4. Got it? Ma'am?
Okay.
So you can actually apply for an H1 without asking a change of status. Okay?
Can I do my change of status here in US?
You can, but the only problem is it's really not a good idea because filing a change of status in H1 is just like filing a new application all over. You are not subject to the quota, but it's the same paperwork being submitted again. Of course, the fees is not as much. So if it is needed for some reason, do it. Otherwise, avoid having to do 2 H1 cases in one case. Once you get the H1, second times you get the change of status. Okay? You good? Can I go on to the next one? Ma'am? I can't hear you. Yeah, hello?
Hello?
Yeah,
Hello, can you hear me?
yeah, I can hear you, but you have to answer me. Are you okay so far? Should I go on to the next question?
Yes, sir.
Okay. Third question. Suppose I don't want to start working in October. Then what would happen? Then you would be out of status. Because in October, you've changed over to H1B and you haven't started working. You would be out of status. Okay. Number 4. Can I come back to H4 again immediately in October 2014? Not in October. Make sure you file change of status back to H4 and the application for change of status get to USCIS before October 1st. So if USCIS receives your change of status back to H4 before October 1st, which is September 30th, then you are okay to stay here, and you will be, when that application is approved, back to H4. You don't have to work on H1B to come back on H4. Okay? Ma'am, I need a yes or no from you.
Yes, sir. Okay.
Okay. Question number 5. Does USCIS have any issues with these visa changes? They have no problem with this change of status. Are there any restrictions or risks involved? Only when you do change to H1, because that's like filing a new application. Okay? As far as USCIS's scrutiny of your application is concerned, they look at all the same things. Do you have an end client letter? Do you have a job that is professional? So they look at the whole thing all over again. You good? Shall I go on to the next question?
Yes.
Okay. Number 6. Can I go back to H1B sometime in the future without quota issues? The answer is yes. So let's say you applied for H1, change of status, got approved. In September, you applied to change of status back to H4. In December, January, February of next year, if you want to go back to H1, are you subject to the quota? The answer is no. What if I have never worked for that employer? Am I subject to the quota? No. What if the employer withdraws my H1 after its approval? Am I subject to the quota? No. Does that answer your questions?
Yes. So you are saying if once my H1B got approved, I can go back to H1 anytime in future.
That is correct. You will not be subject to the quota for the next 6 years. Okay?
Okay.
Then you had some other follow-up questions. Oh, I've already answered them. If you don't work on October 1st, you will be out of status. How long can I stay on H1B if I'm not working? Oh, that's not an easy question to answer. I would say it is best to assume that without a medical reason or some very pressing reason, it is not a good idea to assume that you can maintain status without working. So you should file for change of status before October 1st. Your next question was, does anybody have any idea of how much is the fees for filing H1B? Ma'am, I don't know about other people. Our fees are on the website. And I'm going to scroll up to the top of immigration.com. Well, actually, I don't have it open. If you scroll up to the top of immigration.com page, on the very top ribbon, one of the entries is fees. If you click on that, you can see what our fees are. I don't know about the rest of the world. Do you have any other questions, or are you good?
Yes, sir. I have heard that USCIS these days, USCIS is inquiring whether you have real job or no by visiting the real company location their job has been offered. Is it true?
So your question is, can USCIS come to my work site to check whether or not I have a real job? The answer is yes, they can, and they do. Not always, but many times they do.
Okay. If they found out that the job is not real, then what would happen?
Please don't get into this situation. Okay? Because if they find out, they can go all the way up to fraud. And if somebody is found to have fraud in their background regarding immigration matters, it is a permanent bar from entering USA. You can never come back. The waivers are very difficult to get.
Okay.
So don't get into this situation. You can also go to prison, ma'am.
Oh, okay.
Okay? Because it's a crime to lie to the government. Good luck to you.
Okay.
All right, guys.
Thank you so much.
Oh, you're very welcome. Any questions at all? Any new questions? Anything anybody wants clarified? Press *5 on your phone, please. *5. 1, 2, 3. That's it? Oh, this one is going to be easy. All right, let's start with, again, in the order that you guys logged in. Whoever logged in first, I'll take them first. Jersey City, New Jersey. Go ahead, please.
Hello, hi, Mr. Rajesh. This is Samir. Samir, Rajesh, two questions. One very related to the topic you just explained. So the H4 to H1 thing. So there's something similar here. My wife is also on H4, and she actually had an H1 converted in 2008. So that H1 got effective in 2008 October, and somehow again, we had to convert it back to H4. So from 2008 until now, which is we are entering 2014 now. So she has been on H4 only. We never converted, and I understand we don't have to go to the quota, and we're not, we don't have to file in quota again. But as of now, since it's the 2014 now, and around 6 years, does it mean that it's after 2014 she will have to go back to the quota if we want to convert for H4 to H1?
I think that is the way it is. I have not looked at the law very carefully from this angle, but it is my understanding that, from what I remember off the top of my head, that the law only forgives us for 6 years.
Oh, okay. And when 6 years means, if that is correct, whatever you said, that means October 2008 to October 2014.
I believe so.
Okay.
All right.
Yeah, but it might be worth verifying again. Okay.
Yeah,
One-
before you file your H1, may want to have the lawyers confirm it. I'm pretty sure I'm right, but I never can say 100% unless I've actually looked at the law. Okay.
Wonderful, no problem, sir. We'll figure it out. And slightly different question. In fact, it's a completely different question, I would say.
Okay.
I'm working with a certain employer,
All right.
and they have filed my green card, and my 140 is approved. But obviously, the dates have gone, way back, and not, we're not able to file the change of status 485
All right.
now. So
Okay.
I was being offered a job, a permanent full-time job, at one of the other locations. And the first, my labor or my firm has been filed there as an analyst programmer or as a developer.
Mm-hmm.
And the two job offers with this new company, obviously they are like there's possibly two options. Either I joined as a developer, and then they file my green card again, form and everything. And secondly, they like for example, in this case, I joined as a developer, but then there's also an option because of my experience and everything. They may offer me a tech lead position, which in more or less, in other words, they also in the practice they call it an AVP. In our form, they have a lot of AVP. So they tech lead / AVP. So do you think that if I join as a senior developer, and then they file my GC, and then later on they want, or I also and they also want me to promote, again want to get promoted. Is it a good idea to get promoted, or there is a problem in the job and the responsibility issue will come up?
Let me clarify something. Your 485 is not yet filed, right?
485, no, the date is not current yet. So it's not
Okay.
filed.
In your case, you can join the new employer with any position you like, because you are not taking advantage of AC21 same or similar job. What you are taking advantage of is just the priority date carryover.
Yes, sir.
Because you are taking just the advantage of the priority date, your job can be any job. You can become the vice president, the president, CEO of Microsoft. We don't care what you do.
Okay.
Or is that job already taken? I'm not sure.
No, I think there is an option. I mean, it's still there available. So the question was, I was not certain that if I change and take a higher job, does it mean that I would lose my priority date then? Because they will say the roles and responsibilities might have changed somewhat. Though it's not drastically changing, though, as I told you, they're still developers, still tech lead job. They call them AVP here in the company. But just because they call AVP, I thought USCIS might think that I have a managerial job now and not a developer anymore, and they may not give me my priority date. That would be a big problem.
My question about is that job already taken was about the CEO of Microsoft. So what I told you was, if that job is available and they offer it to you and you take that job, you can still carry your priority date forward. So it does not matter
Okay.
what your next job is, because you are not relying upon AC21 portability, which requires same or similar job. You are only taking forward the priority date for which the two jobs do not have to be same or similar. You can take an absolutely different job, there is no problem.
Okay, okay. Thank you, sir. Sir, now a similar thing if initially they don't offer me that AVP job, and they initially offer me only a developer job, and I filed my GC from from scratch, labor and everything 140, and down the line, like maybe a year or 2 years down the line, they say, okay, now we can promote you. At that moment, since that it's already priority is already ported and everything, or maybe the process is still in place. Once the labor or the application already been filed and will be approved, at that moment, if they want to promote me, should I accept that promotion?
Not unless you want
Can I
to,
accept that?
not unless you are okay in starting the green card all over again. Chances are you would then have to start your green card all over again, but you still carry the same priority date.
Oh, no, no, no. Of course, the other issue is that I don't want to keep filing labor again and again. So, yeah. So the point is that the labor, once it's been initiated as a developer, and then they may move me to tech lead, then it would be a problem. Then I could not accept that tech lead because I don't want to file the labor.
Well, why? How does it matter to you? They are the ones paying for it. Let them do it.
But sir, filing again and again also.
So what? So what?
is
It's
a
not.
problem.
It's not like there is some kind of a wear and tear involved in this. What is the problem? Do it again.
Yeah, because the labor is already taking 7-8 months these days, as I came to know, and maybe we have 6 months or 8 months. My labor is approved, can go back and file again.
Can I ask you? Can I ask you a question? Is there a reason why, even though you're working as a developer, they cannot file a green card as an AVP? It's allowed. Green card is
File my green card, they would only offer. Go ahead. Yeah.
green card is for a future job. It can be a totally different job.
Oh, yeah, you're right. I can ask that question to them.
That's what I would do.
Actually, what I've heard is that normally, okay.
Okay.
Yeah, but normally what I've seen in the history that they file for the same position when the person is working there at that moment.
There's no such.
That's what they've been
There's
doing.
no
But
such.
it's what happened.
There is no such thing as normal. Every case is different,
Okay.
and your lawyers should be advising your employer, or their lawyers should be advising them that, guys, we love to do repeat labor certifications because we make money, but if you want to avoid unnecessary legal expense and time and trouble, you should just file for the next higher job if you are reasonably certain that by the time he gets his green card or before, you intend to promote him.
Oh, okay. All right, sir. Sir, last thing, is there this immigration reform any ray of hope right now? I mean, because that is the only hope which we can deliver. These dates are so bad, it feels so frustrating. So we were thinking that something might happen in the first quarter of this year. I mean, it's because you're so close to all those, issues, and probably you're the best person who might know if something is happening. Is it worth waiting? Because I was thinking that it's worth waiting for a few more months, and I don't accept this move. Maybe I would accept it after my EAD arrives. So,
Ask
anything-
me,
is that
ask
anything
me,
positive happening?
ask me that question in June. If you want a more comprehensive statement, watch my radio show from yesterday. It's posted already on our website as well as on our YouTube channel. But in a nutshell, we don't know yet. We'll see. There is a lot of backlash within the conservative Republicans who don't want to see anything happen. But for the first time in many, many years, both labor unions and businesses want reform. And we all agree that legal reform is something that needs to happen. I don't see why we cannot do that. But in any case, it's uncertain. I don't know what's going to happen yet. Okay. Follow my tweets. I have a Twitter account. Follow my tweets. Download our apps. We update the apps. We had some technical difficulties. They are resolving them now. but we have free apps that we also update very frequently. Okay?
Oh, okay. Wonderful. Thank you very much, sir.
You're
I'll
welcome.
definitely follow that.
You're welcome. Good luck, sir.
Thank you.
Okay, I have two more questions left. Campbell, California, go ahead, please.
Rajiv, this is question number 21, EKS 341. I wanted to clarify a few more things here
Okay.
to be sure that I'm doing the right thing. So, I hope you have the question in front of you.
Your
regarding the
situation is
three-year H1B.
actually your situation is not as complicated as you are making it out to be. I've already told you what you need to do. You have only 13 months of H1. You should let your lawyers decide what they want to do, whether they want to amend or not. But you should behave as though you have 13 months. Get your green card filed as quickly as possible. End of story. What else is there?
Okay. Okay. So, yeah, I think that part is very clear to me. I just want to make sure that what I communicate to the attorney of the company is very clear and precise. That's why I'm asking for clarification.
Feel free to
If the
play.
H1B petition-
Feel free to play them this recording.
Yeah, I would definitely love to do that. So, I had lost my job on Jan 10th, and I had filed a visitor visa petition on Jan 10th itself. And the H1B petition, this petition which got approved for 3 years, was filed on, I believe, 25th of Feb, around that date. When I went through the H1B petition as filed by the attorney, I think there was nothing mentioned about my visitor visa petition. And there are two questions that I have. One, if the attorney did not mention anything about my visitor visa petition, was that an error or something wrong about it?
Yes, that was an error.
And
That was an error, and that is a material error. It should have been brought before the USCIS.
okay, okay. And the other question is, what should I do regarding that visitor visa petition, which is still pending as of now?
That's a difficult question for me to answer. It depends upon what your lawyer wants to do. So you put your email to the lawyer with a CC to the employer and put all these things down. Let's see what your lawyers want to do. If they want to amend the H1 with this new pieces of information, you should let your tourist visa application stay. If they want, on the other hand, to not do anything about it, I think you need a second opinion. They should be correcting the situation.
They should be correcting the situation.
Yep.
That's what you
Yep, they should be pointing out to the government both things, that, oh, by the way, when we filed the H1, we neglected to inform you that there's a tourist visa application pending, and that when we filed the H1, he was not in H1 status. And two, that we miscalculated the time and put in too much time.
Okay. All right.
Anything else?
All right. So I would communicate these things to the attorney as well as my employer.
Okay, very good.
Given that the H1B has already been approved, I have officially started working for the employer. Is that right or wrong?
I think that's okay. I think that's fine.
Okay. All right.
You're not required to be an immigration law scholar. I mean, you are doing whatever the government gave you. You are acting on it. I think it's fine.
Okay. Yeah. I mean, I think well, I want to make sure that I'm not making a kind of big mistake here.
No, I don't think so.
All right.
I don't think so at all. Okay?
Okay.
Good luck,
Thanks a lot, Rajiv. That was helpful.
You're welcome. Good luck. Okay, so guys, while we were waiting, the number of questions went up. So let me take it from the beginning again. Four questions, four people more total. Marietta, Georgia, go ahead, please.
Hello, sir. I have one confusion that if my H1B got approved, then what are the difference if my change of status is filed and if it's not filed? What would be my status in either these two cases?
Ma'am, that's why I asked you every time I answered your question. I wanted to make sure you understood before I went on to the next question. This time I will answer, but please don't make me repeat it again because we are spending too much time on just one set of issues. Okay? So, very simply, if your change of status has not been filed, on October 1st, you will have H1 approval, but your status will still be H4. Are you clear? If you wanted to start working on H1, you would have to either get a change of status to H1 or you would have to go outside USA for visa stamping and come back on H1 visa. As long as you stay inside the US without a change of status or H1 visa, you would continue to be on H4.
Okay.
Have you understood?
So my H1B approval is once approved, but I'm still on H4 because my change of status is not filed.
Absolutely. You got it. Yes, ma'am. You have it.
So in future, can I go for the H1B again without exempt quota?
You can. My only concern with this situation, you're definitely exempt. But if you wanted to, let's say, change back to H1 after 6 months, the government could question that why did you not apply for a change of status? How come there is still the same project waiting for you? If you do it with a different employer, no problem.
Okay.
Okay. I'm going to move on.
Thank you.
Okay, good luck. All right. Jersey City, you're back again. Go ahead. All right. That one is out. Last two questions, guys, then I've got to go. Syracuse, go ahead, please. Syracuse, New York.
Hi. Yes, sir. I do have a question regarding. So I lost my job recently.
Okay.
Unknowingly, I was under the impression like having a paycheck and my H1B not cancelled will put me in a still legal status. But I found out that as soon as I get a letter from the company saying like this is your last job, this is the last day of working, I'll be out of status, even though they don't cancel my H1B. Is that correct?
Well, the jury is still out on that one. Okay. Government has said at various times that they don't consider severance pay to be salary. So they would consider somebody to be out of status from the date there was a job cessation and the regular salary was gone. If your pay stubs, on the other hand, are not severance but continue to be regular pay and you're not actually working, I don't think you're out of status.
Okay, but I mean, just looking at the pay stub, I'm not sure like how can you say like.
Well, sometimes the pay stubs memo field will say severance pay.
Oh, okay.
Okay. So, but even if it did say severance pay, it's a gray area of the law. It's not that clear cut.
Okay.
So, if I were you, I would not lose sleep over this issue.
Okay.
You have enough
I mean,
you have enough problems to worry about looking for a new job. I won't worry about this issue. I think your lawyers can make a case
Okay.
that you are still in status.
Okay. I mean, I already found a new job and we're
Good.
actually doing the H1B processing, but they'll probably file for the LCA today or tomorrow.
Yeah.
And my only doubt is like, I mean, technically from my company, I'm supposed to get a paycheck like tomorrow, and the last paycheck will probably be on next Friday, which will be the end of the severance pay.
I think your lawyers will be able to make a case for you. We'll see how it plays out in the end, but it's not a clear-cut area of the law. Okay?
Okay. So worst case, say for example, when I do my H1B through my new employer, and if I don't get a if I don't get a I-94 with my new 797, what happens in that case?
Well,
I'm supposed to go out of the country and get my I-94 in 1 week.
you'll have to go get your visa stamping done. Make sure you file the second case premium processing, okay?
Yes, it is being done in premium processing.
Yeah, I don't see any problem. Worst case scenario is a visit outside USA for visa stamping.
Okay. And also, will this have any effect, say, if I don't get my I-94 and if USCIS thinks I'm out of status for 10 days or whatever, will there be any negative effect on my green card, like I-140 or 485?
No.
Okay.
All right?
All right, that's all I had.
Good luck, sir. No worries. Bye-bye.
Thank you.
Okay. This one is the last question, guys. Seattle, Washington. Go ahead, please.
Hi, Raju. So I asked this question 2 weeks back, but I was unable to contact back at the time, like my star file was not working. So this is regarding filing the H1B. So I am with company A and they are filing H1B for me this year. And if I file another H1B with a different employer, so I'm wondering, for example, what happens, my company A H1B doesn't approve and company B H1B approves, and on October 1st I will be out of status, I will be on H1B with company B and I can't work with company A anymore. So you suggested that going to Canada, like for example, if there is some complicacy with company B and if I can't join with them on October 1st, you suggested that going to Canada and coming back on L1, is that possible, and continue working with company A?
Definitely. The way it would work is, let me summarize your situation and make sure I've understood it. You are currently working on L1. You are filing through company B and H1. October 1st, you will be automatically on H1, not L1, because you have applied for a change of status. So if you wanted to convert back to L1, one good way to do that is, because you have an L1 visa stamping on your passport, you cross the border and come back using your L1 visa.
Okay.
And then you're back on L1.
But my concern is that my employer, like for example, October 1st, because I am not eligible to be on L1B, he will be terminating my employment, right? Or is there some period like the 30 days or something that I can still continue be?
There is no such period.
Should I do that exactly on?
Just take 3 days off, September 30th, 1st, 2nd, something like that.
Okay. And okay, so while I am coming back, I can say that, okay, I still want to, for example, the officer will definitely ask to come back on, why are you coming back on L1, right? So I can say that, okay, I want to continue with the company A only and cancel the company B H1 or something?
Yes. What happens is, if you go to Canada or Mexico and your trip is less than 30 days, you don't really need to present a visa. You can actually re-enter on your L1 I-94. Okay? But you can tell them, look, I need a new I-94 because my another employer had applied for an H1 and there was a change of status on October 1st. I want to continue on my L1. Please give me a new I-94 on this L1 visa.
Okay.
And you are entitled to it. You are entitled to it. It's not something you're asking as a favor.
Okay. No, actually my point is that actually I did a similar thing for my wife recently with your suggestion. So I did it after like October 1st. For example, once she is on H1. So for example, if I go before October 1st to that guy and say that, okay, I am still on H1, but I need a new I-94 on L1.
You have to do it on October 1st or after October 1st.
Okay. And I was wondering that is it possible to ask the new employer not to change of status automatically? I heard of counselor or something.
Yes, of course. You can apply for an H1 without a change of status.
okay, I mean, whenever I need it, like for example, if I want to join them in November or sometime, then I can ask them, okay, to change status to H1 and join them.
We had a full discussion about this issue just a couple of minutes ago. And the answer is yes, you can do that. I don't like it because you have to file the same paperwork all over again. You can go for visa stamping also, H1 visa stamping. But if that's what you want to do, that's fine. It's legally allowed.
Okay. So, what happens, like, for example, if my company A also filing for H1, and if both of them gets approved, do I have an option to, say, continue with the company A? For example, if my company A and company B, both H1s gets approved, is there a way to continue with the company A?
Is company A the company who also has your L1?
So my company A is also filing for H1.
This is the same company for whom you have an L1?
That's correct.
Okay. So your question is, if two companies file for my H1, both get approved, can I choose one over the other?
I mean, can I continue on the L1 company as a H1?
Same problem, change of status problem. As long as there is no change of status, you can cancel anything you like.
Okay, yeah, I got it. So, I mean, because, for example, is it possible to cancel before October 1st itself? For example, I know that, okay, my company A got approved as well, and at the time, can I cancel company B's H1 before October 1st instead of, like, waiting till October 1st to come into the status and all?
Definitely.
Can I say that before October 1st itself?
Yes, you can. You can request them to revoke the H1, definitely.
Okay, yeah. And one last question. So I changed like my wife's status from H1 to L2, like by going to Canada, and her employer told that he will be revoking her H1. Like, is that fine, or like does it have any implications? So she is currently on L2, and for example, if her employer revokes her H1, I'm just wondering, like, is there something he will do that affects us or something, or like we can ignore it for now or continue to be on L2?
You can ignore it. There is no problem.
Okay.
All right,
so
sir.
later, like for example, if she wants to.
Look, I have to really go. We are a little bit over time.
Okay.
But I will answer. I know what you're asking. If your H1 has been approved, then revoked, is she subject to the quota? The answer is no, she's not subject to the quota. Okay?
Okay. No, I was wondering, like, yeah, she can come back with a different employer, right? Like later for H1.
That's exactly what it means. She's exempt from the quota. Any employer can do an H1 for her.
Okay. Yeah. Thanks a lot, Raju.
You're welcome. Good luck. I will talk with all of you in 2 weeks, guys. Thanks for being here. Bye-bye. Every other Thursday at 12:30 p.m. Eastern Standard Time, we host free community conference calls. Everybody is welcome to join. Some people post questions ahead of time. You can take membership in our forums. All of the details are there on our website, immigration.com. You can take membership ahead of time, and it's instantaneous. It happens right away. And post your questions beforehand, or you can just log in. The phone number and all are provided: 202-800-8394, 12:30 Eastern Standard Time, every other Thursday. We have free apps for both Apple iOS platform for your iPhones and iPads, as well as for Android. Just look for immigration.com, the period dot, and the application should show up.